This is Paul Turner, the Immigration Barrister at Imperium Chambers. Thank you for tuning in. Please subscribe to my channel, and if you have an immigration problem, please get in touch with me. Today I'm going to be talking about what now for EUSS marriage cases after the Upper Tribunal decision in Celik, reported at 2022 UKUT 00220 IAC. On the face of it, and for the reasons that are going to be set out below, this is not a good decision for those people who have EUSS appeals. Though it does open the door to those who might well be refused under the EUSS to utilise Article 8 or to make applications based upon marriage, relationships and Article 8. A further glimmer of light, this is introduced by the Home Office, is that it is now possible for people to make applications from abroad to join someone with pre-settled status, as opposed to previously someone having to have settled status or indefinite leave to remain. So this, while going home and making the application from abroad, may provide a solution which is, on its face, more legal and potentially more successful than fighting on in the UK. By more legal, I mean complying with the Home Office's own rules. If you are facing an EUSS appeal, it might well be a good idea to get advice and see what can be done and whether there are any other options open to you. It brings me no pleasure at all to go into the details of the case, but it does merit a video as it affects a potentially large number of people. And I suppose that the only hope following it is that the Court of Appeal gets to look at this matter more closely. On a personal note, I find it somewhat galling that it's because of the government's decision to put into place the COVID lockdowns that prevented so many people from getting married, that these same people who could not get married are being punished as the Home Office itself did not extend the transitional period for EUSS applicants and therefore appeals. Now turning to the decision in Celik, and it is unfortunately a case that's going to be affecting an awful lot of people. Although the case of Celik concerned a Turkish national, it will apply to individuals' EUSS cases involving other non-EEA nationals, wherever they're from. The facts of the case of Celik, and I hope I pronounced that correctly, essentially and other cases go somewhat like this. The applicant is in the UK unlawfully and forms a relationship with an EU national sometime in 2019 or 20. They may begin to live together during this period and become engaged. As everyone knows, in 2020 the UK was in lockdown for most of the year. Many people were unable to get married because registry offices were simply closed. This was a government's decision. Even after they opened, due to the fact that they were closed, they had huge backlogs. In fact, many clients, including many of my clients, were not able to marry until after 31st December 2020. This date is crucial because it's the end date of the UK's post-EU exit transition period. As I've mentioned before, the Home Office, despite introducing the COVID restrictions, did not extend this period. If a person was married to an EU national before this date, they met the definition of the term spouse under the EU settlement scheme, so they were okay. If they were not married before this date, they did not meet the definition of a spouse because they no longer had the benefit of the EUSS or the EEA regulations 2016 in the same way. I'm aware of many clients who are in this position who made applications under the EUSS scheme before it was finally closed in June 2021. A large number appealed and were at the first tribunal. They were successful in their appeals. Unfortunately, of late, I am aware that there have been a large number of appeals made by the Home Office to these successful appeals, and that a number of cases have been heard by the UT, though they were unreported. However, the case of Celik is important as it's the first reported case on this particular issue. Unfortunately for appellants, it's very bad news. The headnote summarises the main points, which are: a person in a durable relationship in the United Kingdom with an EU national has as such no substantive rights under the EU withdrawal agreement unless P's entry and residence was facilitated before GMT on the 31st December 2020 or P had applied for such facilitation before that time. Secondly, Where P had no substantive right, P cannot invoke the concept of proportionality under Article 18.1r of the Withdrawal Agreement or the principles of fairness in order to succeed under an appeal under the Immigration, Citizens' Rights, EU Exit Regulations 2020, otherwise known as 2020 Regulations. That includes a situation where it is likely that P would have been able to secure a date to marry the EU national before the time period mentioned in paragraph subsection 1 above, but for the COVID pandemic. A full reading of Celik is very disappointing. The UT held that the appellant's residence must be facilitated by the issuance of a residence permit in order to be considered a durable partner, as opposed to providing evidence that they live together. The upper tribunal further held that the appellant could not rely on the principle of proportionality because he did not come within the scope of Article 18.1r of the Withdrawal Agreement. This is because they are not a spouse or a family member. There does remain some hope, however. I'm sure if the appellant in Celik is appealing, but there are no doubt there's a large number of other cases in the upper tribunal. It may be that the Court of Appeal do look at this matter, maybe that they come to the same decision in Celik. However, it is of my view that this is not the last case on this particular issue. As I say, what I find particularly galling is that there are a large number of people who fall foul of the law in Celik on a strict reading, as the upper tribunal found, of the relevant law, but they only found themselves on the wrong side of the law because of the government's lockdown and the government's closure of the registry offices and the subsequent backlog. So essentially these people are suffering directly as a result of the UK government's decision to lock down the country during COVID, which wasn't matched by an extension by the Home Office to recognise this fact. So there's an awful lot of people who might feel fairly aggrieved at the approach the upper tribunal have taken, given what the Secretary of State actually did. But I didn't write the withdrawal agreement, I certainly didn't agree to it, and I certainly wasn't in favour of Brexit. Having said that, we are where we are. This is an important case. It is going to affect a large number of people, and therefore it has merited a video. I would say I hope people have enjoyed this video, but it's not the bearer of great news or great tidings or great concessions. However, it is an important case, and it is the first, as I say, reported case in respect of EUSS bills from the upper tribunal. As I say, whether it will be the last, or whether the Court of Appeal, if they get seized of the matter, come to the same conclusion, is another matter. But as far as it goes for today, Celik is the law, and there are a large number of people who will have fallen outside the provisions for the reasons that I've set out above. I hope this video has been at least informative. As I say, there are a couple of options. One is obviously to return and apply from abroad, because that is an option that is open under the rules, and I would encourage anyone to follow the rules in that regard. And secondly, Celik did not shut the door on Article 8, though it didn't really open the door, it just didn't shut the door completely in respect of Article 8. If you want a further reading of it, or you want any further information on it, please do not hesitate to get in touch with me. Thank you very much for watching. This is Paul Turner, the Immigration Barrister at Imperium Chambers.